Donald Trump wants to capture 9 out of the 12 votes of the Federal Open Markets Committee controlled by the Federal Reserve so that he can set rates. And the way he can do it is by taking out one person. If he takes out Lisa Cook from her 14-year tenure in the Federal Reserve, he'll get the 4 majority votes he needs on the Board of Governors. He'll be able to fire all of the Federal Reserve presidents, all the regional presidents, the 12 presidents, and he'll get to dominate and have ultimately 9 votes instead of just 3 in order to set rates. And what happened today about that? He just filed his quote unquote emergency application to the United States Supreme Court to appeal his second bad ruling against him, this time by the DC Court of Appeals, who ruled 2-1 that he can't take out Lisa Cook because it violated her due process rights. And the prior judge, Judge Cobb, who ruled that there is no for cause. And it's not what the president says. There has to be a due process element to it. There has to be sufficient cause to remove a governor of the Board of Governors of the Federal Reserve. Otherwise, what is the protection? The Supreme Court said in May, in a case called Wilcox and Trump, that you cannot remove a Federal Reserve participant, let's say the chairman or a board of governor member, without for cause. To hear Donald Trump tell it in his new filing, which of course I'm posting on Legal AF Substack, to hear him tell it, as long as Donald Trump identifies some cause, that's enough. Well, what's the difference between that and just being able to fire them without any cause at all? Donald Trump's argument, he actually makes this to the Supreme Court, is effectively, because you gave me immunity from criminal prosecution, what does that have to do with anything other than the same guy is involved again, John Sauer? Therefore, I have preeminent powers and robust executive powers, and I can if I say somebody is not doing their job and it's a for-cause termination, that's enough. They don't get a hearing, and federal courts don't get to review what I say. It's fully at my discretion. Where do you get that from? Well, there's a 1901 case. I'm like, oh, here we go. There's a 1901 case having nothing to do with this matter. What he's ignoring is the long line of cases that say when something says for cause, what it means is you go back to all the case law and the precedent, and that says it has to be for something on the job, some sort of misconduct on the job, something that's been identified, and they get due process. Donald Trump's argument in the new brief, I'll read to you from some pages, is no due process. She has no property right to stay in. Judge Cobb and the judges of the DC court, 2-1, said she does. That because she's got a layer of protection with the for-cause termination on top, that creates a property right. Sounds good to me. Sounds right to me under the Fifth Amendment. And then they argue, well, even if in the brief, they say, well, even if she is entitled to Fifth Amendment due process, she got it. And I'm like, well, what was it? Well, Bill Pulte, go on. Bill Pulte, who runs Freddie Mae and Fannie Mac, he bought his way onto it because he's a big donor to Donald Trump, of the Pulte construction family fortune, wrote a mean tweet suggesting that she committed mortgage fraud when he was wrong. In fact, his own parents did exactly the same thing and were caught. The same thing is having checked the box for 2 mortgages to be your primary residence. So what? Everybody does it. 4 members of the cabinet for Donald Trump did it, including the Treasury Secretary. ProPublica outed 3 of them, and Bloomberg outed the other one. The Labor Secretary, the Transportation Secretary, the EPA Director, and the Treasury Secretary, Scott Bessent, all did it because it's not a fraud. Because Lisa Cook, and there's evidence already been established by Reuters and other exposés, she properly told her bank that this was going to be a secondary home for her, a vacation home, a condo in Atlanta. She had a main home in Michigan. She took her primary residence property tax credit or classification in Michigan, not in Atlanta. But Bill Pulte doesn't want to know about that. He's already accomplished his goal. He's got judges, and now in this filing to the Supreme Court, calling it apparent fraud, not alleged fraud, apparent fraud. And that's enough for John Sauer to accuse her of fraud, frame her for fraud, and then say Donald Trump has the grounds to fire her. Let me read to you from this. Let me tell you that, just to save you some time also, in the 38 pages of this brief, they don't mention or they don't discuss in depth the Wilcox decision from this summer about the Federal Reserve and the removal of a governor for cause at all. They mention Black's Law Dictionary and the criminal immunity case, which has nothing to do with this, more than they mention the case from this summer about this very issue. Isn't that odd? Isn't the people who are writing the opposing brief going to find that odd? Here's what they say on page 2. When her apparent misconduct came to light, that's the mean tweets, the president determined that Cook's deceitful and potentially criminal conduct in a financial matter renders her unfit to continue to serve on the Federal Reserve, and at a minimum demonstrates the sort of gross negligence that calls into question her competence. To this day, Cook has never attempted to reconcile these representations. Where? Where's the due process? Where's the hearing? Where's the judge? Where's the evidence submission? Nowhere. Or offered any substantive justification. Okay, she needs due process. She needs to be able to bring in this evidence to defend herself. But you're saying there is no due process and she has no ability to provide it. So which is it? And then this apparent mortgage fraud was picked up from Katsas, the judge in the D.C. Circuit Court of Appeals. He was in the dissent. He convicted Lisa Cook already. He didn't say alleged. He said apparent mortgage fraud. Picked up again here by John Sauer. Apparent mortgage fraud. Just because you say it over and over again does not make it so. But then here's one of my favorite arguments is that the determination of cause, whether there's for cause or not, this is on page 20, is committed to the unreviewable discretion of the president. They go through a series of cases from like 1901 that says, well, if Congress gave him the power to say for cause but didn't define what for cause is, you don't look at the case law. You just give him unfettered ability to fire at will. Well, then that's firing at will. That's not for cause. Then what's the protection? Here's what they say on the bottom of 24, just to show you how ludicrous their positioning is. Finally, the district court worried that the government's argument would mean that in practice, the president could remove members of the Federal Reserve Board at will. That's incorrect. It's not at will. If the president provides no reason at all for removing a member, a court could properly review the discretion. But once the president identifies a cause, judicial review must cease. It's whatever Donald Trump says it is. It's not reviewable. All right. This is ridiculous. The Supreme Court should properly apply their precedent from just this summer, in May, in the Wilcox case, Trump and Wilcox, in which they said that you can't remove a Federal Reserve person without for cause. Although they didn't define cause, there's a body of law that defines for cause as something you do in misconduct on the job. Not checking a box in a series of mortgage applications before you got the job, even if that were proper. And they should not stay this case, and they should not disturb the status quo. She's already in the job. She participated yesterday in the Federal Open Markets Committee meeting. She was one of 12 votes, 11-1, to cut rates by 1/4 point interest rates. Let her do her job. Let her defend herself against the framing. The Supreme Court should reject this emergency appeal on the shadow docket and let Judge Cobb do her job with instruction to develop a proper record to bring this case back up on appeal. And if the Supreme Court wants to take it on an emergency basis, and I mean 4 of the MAGA right wing, then you have to have full briefing and you have to add an oral argument. Because if you're going to take away the independence of the Federal Reserve, you better do it with an oral argument for the American people to watch. And if you do, we'll put it up on Legal AF on Substack. Next step is John Roberts considers whether to throw it over to the full bench, all 9, to make a decision whether this comes up as an emergency appeal or not, and whether there's going to be a stay or not. And then ask for full briefing. He'll ask for another brief, set oral argument, etc. So we're a long way from Lisa Cook being removed, but the final word is going to be the United States Supreme Court, whether it's now, emergency shadow docket, when the new term opens on October 7th or whatever. Follow it all here on Legal AF. We have a show called Unprecedented that I do with Dina Dahl. It goes up every Saturday in our second video, Saturday morning, second video, about 11:30, where we go over all things United States Supreme Court. And we will cover this in more detail tomorrow during our Saturday during our Unprecedented show. Hit the subscribe button, come over to Legal AF Substack, become a member, and you will be able to access a copy of this brief so that you can also read it for yourself. If you become a paid member, all the better to help keep us on the air. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.